I want to go ahead and start. I think we're starting about a minute or two ahead of schedule, which is always good for government. I want to thank all of you for being here today. I want to greet everyone. Today is a historic day for South Carolina on a number of fronts. I want to thank the Secretary for taking time to come down here. I want to thank Congressman Wilson's member of the local delegation from Aiken. I also want to thank Senator Graham, good to see you, Representative Taylor, for making time to be here. This underscores the importance of the settlement that I'm here to announce today. Today's announcement is historic. This $600 million settlement with the Department of Energy is a record breaker for South Carolina. It represents the single largest settlement in South Carolina history. It ends years of contentious litigation with the United States government. It contractually enshrines obligations on the federal government over the long run that will prevent South Carolina from becoming a nuclear dumping ground. And it brings in well over $500 million to the state at a time that South Carolina needs it the most. And again, look at who's standing up here just to underscore the importance of this historic moment. The journey to this point today was a very long and complex and contentious journey. However, because of the hard work of our team here in South Carolina and of the team with Secretary Dan Brouillette, we were able to hammer out an agreement in which everyone is a winner. There are no losers, only winners, especially, in my opinion, the people of South Carolina. It is important for the people of South Carolina to know what today means for them, but first I would like to describe what it took for us to get here today. So I would like to briefly go over the litigation history so that you understand in context what today means. In early 2000, the Department of Energy elected to construct the MOX facility at Savannah River Site in Aiken, South Carolina. And they did this to dispose of defense plutonium and defense plutonium material. Beginning in April 2002, DOE, through the National Nuclear Security Administration, began transporting defense plutonium and plutonium materials to South Carolina. This was done in anticipation of the plutonium being converted into MOX fuel at the completed MOX facility, basically converting swords into plowshares. From that point forward, in 2002, NNSA, which is the National Nuclear Security Administration, under the Department of Energy, has been transferring up to 10.5 metric tons of plutonium to the state of South Carolina for the purposes of being processed at what would eventually become the MOX facility, had it been constructed. We learned in 2014 that the previous administration had made the decision to terminate construction of the MOX facility. Our first lawsuit was to fight to keep open the MOX facility and to preserve a pathway of the removal of plutonium, as was originally thought to happen. We brought a lawsuit in 2014 which temporarily kept open the MOX facility, but we eventually lost that fight. But we did not give up. We turned to the rule of law. Federal law stated that if the MOX facility was not constructed by a specific date, then the federal government must move 1 metric ton of plutonium by January 1st, 2016. 1 metric ton by January 2016. Federal law also stated that if 1 metric ton of plutonium was not removed by the statutory date, then the federal government would pay the state of South Carolina economic and impact assistance payments of $1 million a day for the first 100 days of each year that the plutonium was not removed. Well, DOE at that time failed to comply with the law in South Carolina's view. As a result, I filed additional lawsuits against the Department of Energy and the United States government. The Federal District Court of South Carolina ordered the removal of 1 metric ton of plutonium, and the Fourth Circuit Court of Appeals affirmed that decision, so we won on that front. The portion of the plutonium that was moved, a portion of that plutonium was actually moved to Nevada, and Nevada sued the Department of Energy to keep it from going there. So South Carolina intervened in the Nevada lawsuit to ensure that once the plutonium left South Carolina, that it would not return to South Carolina. So we went and we fought in the Federal District Court of Nevada, and we even appealed that up to the Ninth Circuit Court for the plutonium to stay. They ruled in our favor. And ultimately, the Department of Energy committed to Nevada that it would eventually remove that plutonium to New Mexico. Finally, South Carolina filed suit to collect the payments owed for DOE's failing to remove the plutonium, or the National Nuclear Security Administration, rather. That's where the $600 million fee comes from. Now, it's important to note, we actually lost that lawsuit as we were continuing to seek injunctive relief in the federal courts. All told, South Carolina fought to protect its rights in 5 different lawsuits going back as far as 2014. We litigated in 3 different trial courts at the federal level, 3 separate courts of appeal, to include, or not to include, but in addition, filed a petition in the United States Supreme Court. South Carolina took its fight to the federal trial courts in the Federal District of South Carolina, the Federal District of Nevada, the Court of Federal Claims. We defended those at the 4th Circuit, the 9th Circuit, and the Federal Circuit. Again, we even took it to the United States Supreme Court. In addition to all the legal fighting, we worked tirelessly with members of our state and federal delegations to resolve this mess. Some of them are here today. In October, I believe it was October of 2018, I flew to Washington, D.C., along with Governor McMaster, Senator Lindsey Graham, Senator Tim Scott, Congressman Joe Wilson, to meet with President Trump, then Secretary of Energy Rick Perry, and Lisa Gordon Haggerty, who was the administrator for the National Nuclear Security Administration. The meeting was good. The President was incredibly supportive of both the Department of Energy and South Carolina working out a plan that would resolve this contentious litigation, and that was helpful. However, real progress started when Secretary Dan Brouillette became the Secretary of Energy. Secretary Brouillette and I had already been friends prior to his appointment, nomination, and confirmation by the U.S. Senate, and we had been good friends prior. It was that working relationship that led to the settlement, which brings all of the parties here today. Again, it was great for South Carolina to show unanimous support for the plutonium to be met, but it was the litigation that brought 2 parties to the table, and it was the relationship between the 2 individuals in these parties that was able to ultimately effectuate this successful resolution, at least in my opinion. Now, that is the history that brings us here today. I'm going to quickly highlight the terms and explain the terms of the agreement and the purpose for the agreement. The U.S. government will make a monetary payment of $600 million to South Carolina. We expect that payment to be within the next 30 or so days. This amount represents the entire payment due to South Carolina under the law from January 2016 through the end of 2021. So 2016 all the way up to this year is $500 million, and then $100 million for 2021, which hasn't happened yet. In exchange for this upfront payment, South Carolina will provide the Department of Energy with a grace period of 15 years to either implement other viable disposition pathways or remove the 9.5 metric tons of plutonium, which is what's remaining after they removed 1 metric ton, and remove it to another location. This 15-year grace period begins in January of 2022 and runs through the very end of December 2036. Basically, the Department of Energy is buying 15 years of peace with South Carolina as it relates to this specific issue. South Carolina will not file lawsuits against the DOE during this time. The purpose of the 15-year grace period is to give the Department of Energy space to safely and efficiently remove or dispose of the defense plutonium without the distraction of having to defend itself through years of contentious and expensive litigation with South Carolina. We arrived at the 15-year number because it took the Department of Energy 19 months to remove the 1 metric ton of plutonium that they were compelled to remove under the court order. So if you multiply the remaining 9.5 metric tons times 19 months, you will get roughly a 15-year period. Now, I've been given assurances by the Secretary that they won't need that much time. They intend to remove it much quicker. But we wanted to give them a reasonable time, and they asked for that amount of time. Now, what happens in January of 2037? January 1st, 2037 arrives, and we're at the end of the 15 years. What happens then? Well, DOE has agreed in the settlement to remain on the hook for all future payments to South Carolina if it fails to live up to the terms of the agreement. Now, how does this look? Well, the law requiring the Department of Energy to pay $1 million a day per day for the first 100 days of each year is still in effect in January of 2022 and the 14 years after that. So for 15 years, that $100 million a year clock is still running. It's important to know. I negotiated what we call a snapback provision in this agreement. Here's how the snapback provision works. At the end of the 15-year grace period, let's say if the Department of Energy has failed to remove any of the 9.5 metric tons of plutonium, then the Department of Energy will be contractually obligated to pay the full $1.5 billion within a few months of that date, by April of 2037. So $100 million a year for 15 years is accruing. The Department of Energy doesn't remove any plutonium. We snap back to 2022, to January, and DOE pays South Carolina what it would have been paying all along had it not removed any of the plutonium. That's what the snapback means. However, if DOE were to remove a percentage of that plutonium, then the Department of Energy would have to pay that percentage of the snapback money. For example, let's say the Department of Energy will remove 25% of the plutonium by the end of 2036. Then DOE would have reduced its $1.5 billion monetary obligation by 25%. If my math is right, it's about, what, $375 million. So instead of paying $1.5 billion, it would only pay $1.125 billion, which is a 25% reduction. Basically, DOE can reduce its monetary obligation by reducing the amount of plutonium, and it's correlated. So if they remove 70%, they only pay 30%, and so on. The purpose of this provision is to basically incentivize the Department of Energy to either completely remove the plutonium or to find a suitable alternative pathway for disposing of the plutonium. I want to emphasize one thing, that South Carolina will not have to litigate against the Department of Energy for this snapback money. Payment of the money happens automatically under the terms of the agreement. There's one more provision I want to highlight. If the Department of Energy were to remove at least 50% of the 9.5 metric tons of plutonium at the Savannah River site, they would trigger an additional 5 years of grace, basically from 2037 to 2042. Now, there's probably two questions that you're thinking. What does this 5-year grace period, additional grace period, mean, and what is the purpose for granting it? Here's what it means. If DOE is successful in removing at least half of the plutonium by the end of 2036, then South Carolina will agree not to sue them in court until 2042. Now, this 5 extra years of grace only applies to lawsuits involving the removal of plutonium, injunctive relief, not any lawsuits to enforce any other terms, but the removal of plutonium. And it doesn't affect the snapback payment. DOE is still paying up to $1.5 billion, or whatever percentage they've reduced it by if the plutonium's not removed, and they still have to pay the $100 million going forward. But if they've removed 4.75 metric tons, that's 50%, then that's a trigger that they have either made a good faith effort to remove the plutonium, or that there is a process in place for disposing it, be it pit production or dilute and dispose. South Carolina gets paid the money no matter what, regardless. The bottom line, and I want to restate this, South Carolina gets $600 million up front. Now, we lost on this claim in the Court of Claims. So Department of Energy is giving this money. They're saying, okay, even though we beat you here, you're going to not fight us on this. We're going to give you $600 million for 15 years apiece so that we can focus on removing the plutonium in a safe, efficient way. In return, South Carolina gets a long-term contractually binding agreement from the Department of Energy to remove the plutonium. South Carolina gets up to $1.5 billion for the first 15 years and hundreds of millions more if the Department of Energy fails to live up to any terms of the agreement. Now, the Secretary will probably say this in just a few seconds when he steps up here. They plan to have this plutonium removed long before. So he's jokingly said, don't be spending the money in the back of your head in 2036 or 2037. But they're going to have a viable pathway for it before that time. But we have given them the space based on the history of what it takes to remove plutonium. You just can't put it on the back of a U-Haul truck. Now, while it may be my signature on the agreement, it would not have been possible if it wasn't a unified effort by all the leaders in South Carolina. As I said earlier, the governor, Senators Graham Scott, Congressman Wilson, myself, others, we all, the local delegations that are here represented today, we all spoke with a unified voice, and that was incredibly helpful. And I want to thank each and every one of them, especially Senator Graham. I think I've spoken to you more in the last 2 weeks than I've spoken to my own wife. I mean, seriously, it has been constant communication, and I appreciate your support when he was meeting with U.S. Attorney General Barr on trying to move this settlement forward, and he was meeting with other officials in the government. we couldn't have done it without your efforts. Senator Scott was right there alongside you, Congressman Wilson. It seems like every other conversation we had is what's the status on the lawsuit, and so I appreciate your help and fighting for the district, the constituents in the 2nd Congressional District. I also want to give a shout out to Congressman Jim Clyburn. His office was very open and helpful and instrumental in helping us move should this settlement fall through. We were prepared to pursue other avenues in Congress. And I left a message for Congressman Clyburn last night and spoke to members of his staff this morning and wanted to make sure that, that he got credit for the role that they played. So at this time, I am going to allow Secretary Brouillette to step up to make a few remarks, followed by Senators Graham and then Congressman Wilson, and then we will come back up here and have any questions and answer period that y'all need. So, Secretary Brouillette.
Great, thank you, Alan. Appreciate that.
Thank you,
Thank you. Thank you all for being here today. It's great to be back in the great city of Columbia, South Carolina. I served here as a drill sergeant many, many years ago, which feels like maybe 5 or 6 lifetimes ago now. But it's great to be back here. Attorney General Wilson, Senator Graham, Mr. Taylor, Congressman Wilson, and I should throw Congressman Clyburn as well as Mr. Blackwell and others, Tom Young and others who are supportive of this agreement. Thank you all for your support, for the hard work that you and your staffs put into this effort and has resulted in this settlement that we see today. I also want to thank the Department of Justice lawyers, and particularly Attorney General Barr, who worked so hard to get this done. And also want to take a moment and thank the attorneys at the U.S. Department of Energy, in particular my General Counsel, Bill Cooper, and his staff who have worked tirelessly over the course of the last few weeks and months to put this agreement together. The Trump administration is absolutely committed to tackling the nation's toughest challenges where previous administrations have failed, including the removal and the disposal of Cold War-era plutonium from the great state of South Carolina. Today's announcement is a guarantee to the people of South Carolina that plutonium will be removed safely from the state, and we will save the American taxpayers over $1.5 billion. As the Attorney General just mentioned, it is my intention to move this material out of your state well before the 15-year period that is articulated in this settlement agreement. As he pointed out, the Department of Energy was required by federal law to remove 9.5 metric tons of plutonium from the state by 2022. These were deadlines the department could not meet, and candidly, I might add, previous administrations perhaps had little intention of ever meeting them. The potential liability to the federal government could have been as high as $2.1 billion. But by working together to achieve a solution that's satisfactory to all, the U.S. government and the state of South Carolina have agreed to an upfront payment of $600 million and a deadline of January 1st, 2037 to remove this plutonium. As historic as this settlement is for the state of South Carolina, it is equally important to the Department of Energy. Through this unique settlement, South Carolina receives upfront money and the realization of the federal government's guarantee to remove the plutonium from the state. And the American taxpayers will save $1.5 billion. This settlement furthers President Trump's mandate to all of us in the federal government, and that is to make good deals for the American people. Saving $1.5 billion is a good deal. This settlement is a model for how states and the federal government can overcome their differences and work together to produce mutually beneficial outcomes that protect the interests of the states and the American taxpayers, as well as protect our national security. I thank Attorney General Wilson and so many other leaders in the Palmetto State who have been strong partners with DOE to get us to this day. This historic agreement could not have been made possible without the leadership and support of President Trump and Attorney General Barr and all of the people you see here behind me. This is a great day for South Carolina. I'm proud to be here representing all who have worked so hard to bring this to fruition. Thank you.
Thank you, Ms. Secretary. Thank you, Alan. I really appreciate your hard work. This is about as well of an ending as we could have expected. This is truly a win for the state. We have $500 million of money that is probably needed now as much as ever. COVID has been tough on South Carolina. Ms. Secretary, it wouldn't have happened without you. I've talked to the President numerous times. We had a very spirited meeting in the White House with the governor, the president, Allen, and Congressman Wilson. I just want to say to Congressman Clyburn, thank you. You're always there to help us whenever you could. It's always been bipartisan. To the local delegation, thank you for understanding how important it is for us to get this right. So it's a sad day too, really. 20 years we've been working on this project. 20 years. And what was the goal? To take 34 metric tons of weapons-grade plutonium in Russia and the United States and turn it from a sword to a plowshare. To take our excess weapons-grade plutonium and make commercial fuel out of it to power lights, not to be used in a nuclear war. That agreement has been abandoned by both sides. So we've gone from swords to plowshares, back to swords. We've got a facility at Savannah Riverside that's about 70% complete, as big as hell. And the idea that we're going to refit it to make plutonium pits may come about, it may not. But what does that mean? We'll be making nuclear bombs in the facility that we're going to dismantle nuclear weapons. This is not a good day for the world. How did we get here? We started a program in the early 2000s, and the NNSA has been very difficult to deal with. They've underfunded this project. There's been a lack of commitment over numerous administrations to see it through. We've had legitimate cost overruns. 34 metric tons of weapons-grade plutonium can make 10,000 nuclear bombs. This material in Russia and the United States was going to be turned into a plowshare. Now I don't know what the hell is going to happen other than it's getting out of South Carolina. That's sad. Those of you from Barnwell County, remember the Agnes facility? Hundreds of millions of dollars were spent in the 70s to engage in nuclear reprocessing, taking a fuel rod out of a reactor and reusing it so you didn't have to dispose of it. That's what they do in France and Japan and other places. That was done and canceled. This was 70% complete and canceled. It started in 2014 when the Obama administration backed off on this commitment, tried to stop construction, and we've been one hell of a fight ever since. My goal was to keep the program alive because the world needs this program. It's not about the 1,200 jobs, and we've had 1,200 jobs over a decade plus now in South Carolina because of the facility. It's about making the world a safer place. We failed to make the world a safer place because I don't know what Russia's going to do with their 34 metric tons of weapons-grade plutonium they promised to do away with. We'll see how all this plays out. But from a South Carolina point of view, you're getting paid money that you're owed by a statute created in a bipartisan fashion by Congressman Wilson, myself, every member of the delegation, including Congressman Clyburn. And the first statute was written by Strom Thurmond and Lindsey Graham. The very first statute protecting South Carolina in case there was failure on MOX was written by Senator Thurmond and myself. And our goal has been to keep the program alive because I think, from my point of view, this is an important step to making the world a safer place. And it breaks my heart that we built a facility 70% complete, abandoned it, and now the plutonium that was going to be into a plowshare is going to leave South Carolina, dilute and dispose. Maybe it works, I hope it does, but it's getting the hell out of here. But it's not going to achieve the ultimate goal of making the world a safer place. When they made the decision in 2014 to wind this program down, it's just been a constant fight. 9 months ago, the Trump administration decided to change course. The idea of getting this material out by 2022 is impractical. This agreement, Alan, is as good as anybody could have done. The statute in question gave South Carolina the leverage we were seeking at the federal level in case the deal fell apart. Used this leverage exceedingly well. You've been to court more times than I can remember. We won some, we lost some, but now we have an agreement that doesn't depend on a statute that may change with the next Congress. What's important to South Carolinians is we have a legally binding agreement that will stand the test of time, enforceable in court, is not subject to the whims of a new Congress or a new president. It's going to happen. It's going to leave. The check is literally in the mail, and there's 1.5 billion reasons for them to do it right. And I promise you, I don't know if I'll be around, but if I am, my ghost will collect this money if I'm not around. This has been a big deal for me for over 20 years. I am very pleased with this agreement. This is the best outcome, given the circumstances South Carolina could expect, and it was a win for DOE, and I want to thank President Trump and the Secretary for getting to yes. I want to thank the local delegation for trying to find ways to make sure that Savannah River site stays viable. The hope is to take this facility and make it into something new relevant to our national security. We'll see how that goes. But we're turning the page on MOX. We're turning the page on MOX, most advantageous to the state of South Carolina, given the circumstances. $500 million is real money. It comes at a time when we need the money in South Carolina. And the most important thing is we have a contract, a legally enforceable contract that's not going to be changed, can't be changed, and the material will leave here in a reasonable fashion. Just want to end with this. In South Carolina, you have 2 monuments to big ideas that failed. Not because of the people in South Carolina, but for different reasons. Nuclear reprocessing is done pretty much everywhere but here. Jimmy Carter's decision to abandon that, I think, has not made us a safer place. The decision to withdraw from the MOX agreement has made the world a more dangerous place, in my view, because only God knows what the Russians will do with their 34 metric tons of weapons-grade plutonium. But I can say this to the people of South Carolina. $500 billion is real money. It wouldn't have happened if we hadn't passed this statute, and it wouldn't happen if we hadn't had a willing partner in the Trump administration and a very vigorous Attorney General to advocate for us. So this long journey on MOX, in terms of its viability, is now over. It's no longer a viable program. We will turn the page. But I promise you, as long as I'm the senator from South Carolina, we're going to enforce this agreement, and we're not going to do this again. We're never going to start something like this without a commitment to get it done.
Ladies and gentlemen, I'm Joe Wilson. I'm very grateful to represent the Savannah River site along with Congressman Jim Clyburn. I also have another insight. I'm the only member of Congress who's ever worked at the Savannah River site, and I know how talented and capable the people are at the site and how important this is to the national security of the United States. Since 2002, and indeed, as Senator Graham has pointed out, we've had legislation that would provide penalties if the removal of weapons-grade plutonium was not successful. And so finally, an achievement. I want to congratulate Attorney General Alan Wilson, Secretary Dan Brouillette. We now have the achievement of the penalty coming forth, $600 million. And then I'm grateful that we have a General Assembly that will be receiving the funds and determining how to distribute the funds, working with the governor. And what an extraordinary delegation. Senator Tom Young, Bart Blackwell, Bill Taylor. I'm really grateful. We've had such extraordinary people on the delegation, bipartisan, working for the affected counties, particularly Aiken, for Barnwell, for Allendale, and the opportunities for enhanced infrastructure, the opportunities to help promote local education, the opportunity to expand broadband, working with the local co-ops and with ETV. Also, we have the opportunity to work with institutions of higher learning that will promote and train professionals to work in the nuclear energy field at the Savannah River site. With Chancellor Sandra Jordan at USC Aiken, we've got extraordinary leader and Forrest Mahan, who is the president of Aiken Technical College. We'll be training the young people of South Carolina to have bright futures in promoting a better South Carolina. It's a great day for South Carolina. Congratulations, Attorney General. Congratulations, Secretary. And again, I'm just grateful to be here at such a successful time for the people of South Carolina.
Again, I do want to thank our local delegation, Bill Taylor, we've got Senator Tom Young and Representative Bart Blackwell. I know that there are others, but they have been a loud voice, as loud as our federal delegation, and my partner Lindsey Graham, Senator Scott. Thank you for your leadership, Senator. You've always been easily accessible for me. Every time I had to call you about something or talking to Barr or somebody or the president, you were there to help us. So, and thank you, Congressman Wilson. And of course, Secretary Brouillette, you and I have known each other longer than longer than your current role, and we've been friends, and honestly, it took litigation to get us to the table, but once we got there, you and your team, it has been a very different experience with the Department of Energy than it has been in years past. Our contentious relationship with the department goes back to Yucca Mountain litigation, and then of course several lawsuits with Mox, and then through this entire process. And sitting down at the table with you, I always knew that you were dealing in good faith, and you're a fair dealer, and you're an honest and honorable man, and I appreciate you meeting me out in the middle. So thank you again. At this point, I know y'all been waiting patiently. I spoke a while because I wanted to try to address as many points in the settlement and break it down for the citizens of our state and for members of the media so that you can understand what it is you're getting, what the benefit of the bargain is. I'm happy at this time to take any questions. If I can't answer them, I'll try. If not, I'll get back to you, or I will have someone up here answer it.